Thank you, Gilberto. Lyle, please.
Hello, my name is Lyle Vanderschaft from Bryan Cave. I'm going to be talking about today aspects that relate to the negotiation of rules, particularly the anti-dumping agreement. To the extent the negotiations do lead to changes to the agreement, there are important things that need to be taken into account. When the Uruguay Round agreement was finalized, I was an attorney at the U.S. International Trade Commission, and we quickly analyzed the agreement and prepared some memos for the commissioners about what changes would occur in the law. And we were also involved in advising USTR and being peripherally involved in the negotiations. And there were a number of technical provisions of the agreements that could have gone one way or another. And for some of the provisions, the end result, which was advocated by a particular group of countries who were opposed to the anti-dumping law, actually resulted in a worse effect rather than a better effect with respect to the anti-dumping law. There are other examples where negotiators believe they got something, but because of the implementation approach in the U.S., they actually ended up getting nothing. So the two themes that I'm going to be talking about today are: be careful what you ask for in these negotiations in the Doha round. You might get them. And second, you might think you got something, but you actually didn't. The first example that I have, probably the most evident, where negotiators opposed to the anti-dumping law wanted a specific provision, was with respect to negligibility. That provision in the anti-dumping agreement requires the ITC and Commerce to terminate any anti-dumping investigation in which any country's imports are less than 3% of overall imports. There's an exception, which is really the wrinkle to the problem, and that is that if all of the negligible countries combined equal 7%, the countries are not going to be deemed negligible. That ended up resulting in a worse legal provision in the United States for people who are opposed to anti-dumping law than was the case before. Prior to that, the U.S. International Trade Commission would decumulate any countries whose imports were less than roughly 1% of market share and had no discernible adverse impact on the economy. It was a very flexible standard, but it was administered by the ITC, which is an independent agency in the United States. It's apolitical. 3 of the members are Democrats, 3 are Republicans. They serve a 9-year term. They're free from the influences of businesses, Congress, and the president. And they were administering the anti-dumping law in a way where if a country's imports were less than 1% of market share, they would be decumulated from the analysis, analyzed alone, and in most cases, actually in every case, the Commission would issue a negative determination. After the agreement was put in place, the Commission was now locked into this new procedure where they had to continue a case if a country's imports were greater than 7% with all the other negligible countries combined. It's an example of where countries who were opposed to the anti-dumping law actually got what they wanted, and it ended up being something they didn't want in the long run. Another example that resulted in possibly an adverse effect for opponents of the anti-dumping law was the sunset review provision. Some countries, such as Canada, would oftentimes terminate anti-dumping orders before a 5-year period, sometimes after 3 years or 4 years. However, when the sunset review provision was put in, calling for a review of an order after 5 years or automatic termination, Canada moved to a focus of keeping orders in place for 5 years as the standard. Prior to that, some orders would actually be terminated before the 5-year period. So again, an example where countries opposed to the anti-dumping law got what they wanted, and it ended up being an adverse result. There's another minor provision that affects Canada, which is avoiding publication of any anti-dumping petition before it is instituted. Some countries will not disclose the contents of a petition or provide it to the public until they actually institute. This sometimes gives a disadvantage to respondents who want to begin preparing but do not have copies of the petition. So again, a provision that was put into the anti-dumping agreement that has led to an adverse result. There are some technical provisions that were put into the Uruguay round by countries that were opposed to the anti-dumping law or how the U.S. was administering it that relate to comparing a home market price to the U.S. price to determine whether there is a disparity in prices and therefore dumping. The Commerce Department, when there were not enough home market sales, would oftentimes revert to a calculated price based on cost of production. Another alternative was to look at prices in a third country that the producer would sell to the third country, and then compare the prices in the third country to the prices in the U.S. to see if there's a disparity and if there is dumping. Advocates of reduced use of the anti-dumping law and that measure advocated for a preference to go to third country prices as a comparison before going to cost of production. Again, it's a provision that was put in by countries that have been burned by the anti-dumping law in the U.S. They got the provision, and I know that I've been involved in dumping cases after that where I would prefer to have the cost of production as the basis to compare, because the end result would be a better dumping margin for our clients. So again, an example where people advocated that what Commerce was doing was unfair. We got what we asked for. We ended up getting a provision that may not be beneficial to us. Another example of getting what you ask for is the dispute resolution provisions. Mr. Palmer mentioned this morning, that the United States was a very strong advocate of very stiff enforcement requirements for dispute panel determinations and implementation of the decisions of the dispute panel or the appellate body. He indicated that now the U.S. is a bit chagrined because being the strong advocate for the dispute resolution provisions, they're now finding themselves the victim of most of the dispute cases and the losing party in a lot of those panel decisions, where they're now becoming subject to the retaliatory provisions that have been put in place to enforce the implementation of the WTO panel decisions. So there's another example that's sort of a spin on the U.S. with respect to provisions that you must be careful what you ask for, because you might get it. There are other examples where in the last round, certain provisions were negotiated for by opponents of the anti-dumping law, and the end result was actually something in the agreement where they thought they had something, but because of the way the U.S. and other countries implement it, they actually got nothing. And that example that I pointed to is the sunset review provision. There was a lot of debate in the Uruguay round about the sunset review provision. The sunset review provision requires that an order terminate after 5 years unless an administering authority conducts a sunset review, and in that review determines that injury is likely to continue or recur and dumping is likely to continue or recur. And I put the emphasis on the word likely, which I interpret to mean probable or more probable than not or more likely than not. However, the U.S. implementation of the sunset review provision has resulted in far fewer revocations of anti-dumping orders than the opponents of dumping would have liked. I believe there are a number of countries who felt they got something in the agreement when the sunset review was implemented into the agreement, and actually ended up getting nothing. We'll see what the revocation rate is in the second round of sunset reviews that are now occurring, but it's clear that many countries were disappointed about the revocation rate in the first round of sunset reviews. Another example of countries thinking they got something when they didn't is the de minimis dumping margin provision. Article 5.8 and 9.4 require that dumping margins under 2% be deemed de minimis, and therefore no dumping order be imposed. However, the U.S. Department of Commerce does not apply this provision to administrative reviews, which are conducted every year after an anti-dumping order is put in place. The U.S. imposes that requirement and that de minimis dumping provision only with respect to original investigations. There are a number of other provisions in the anti-dumping agreements that are very technical in nature, concerning, for example, regional industries. There's a provision that says if you're going to look at only a regional industry to see if they're injured rather than the entire U.S. market, you can. And there's a provision that allows duties to be levied on only imports into that region. The U.S. takes the position, there's an exception, I should say, to the agreement that says if your constitutional authority does not allow imposition of anti-dumping measures on a regional basis and only on a countrywide basis, you can have an exception to that requirement. The U.S., of course, takes the position that its constitution doesn't allow regional application of dumping measures, despite the fact that that conclusion has never been tested by our Supreme Court. There are a number of other provisions relating to standing for the domestic industry, whether or not they have support deadlines of questionnaires in ITC proceedings, consideration of end users and purchasers in the analysis of the determinations by the administering authorities. The agreement has provisions on all of these measures, and it's my conclusion that the provisions that were advocated by a number of the WTO members when they were negotiating these agreements have not resulted in the types of provisions that they thought they got in the agreement. And the reason why this has occurred in the U.S. in particular is that the statement of administrative action is really the controlling interpretive decision of the agreement when it comes to the Department of Commerce and ITC implementing the anti-dumping agreement. The U.S. will implement any Doha round agreement under our fast-track legislation. And under those provisions, all of the legislative history that will discuss the agreement and what the terms are of the implementing legislation and so forth will be contained in what's called the Statement of Administrative Action. It's basically the administration saying, here's what we negotiated, here's what the law is going to have to do, here's what the agreement says. So that's what the provision in the law that we've drafted entails. It's called the SAA, the Statement of Administrative Action. It is the authoritative expression of the interpretation of the agreement. And after the Uruguay round, I was involved at the ITC in helping draft the SAA. The ITC had a role in providing comment and advice, and it was very clear to me that the U.S. producers who were opposed to the anti-dumping changes that were negotiated in the agreement were having a very strong influence in drafting the SAA, and now, of course, the SAA has predominant influence among the agencies and the courts. So one lesson to also take away from this is that the effort is not going to end after the agreement is made in the Doha round and parties return to their countries to implement those agreements. In the U.S., the second phase of all efforts will begin when the SAA is drafted, and people have to have an involvement in that process in order to affect what the actual law is in the U.S. after the agreement is implemented. Thank you.
Thank you, Lyle.
Good afternoon. My name is Terry Stewart. I'm a managing partner at Stewart & Stewart here in Washington, and I guess I'm here as a petitioner's counsel. I have a presentation that I don't see. There we go. Thank you. Do the slideshow. What I wanted to do was give you a bit of an overview of the position of rules in the WTO, its changing roles after the Uruguay round, and where the process is as we go into Geneva. As most of you would know, measures to address injurious dumping have been part of the multilateral system since its creation, and in fact for a number of countries have existed since the start of the 20th century. Article 6 of the GATT lays out the basic right of members to address injurious dumping through the imposition of additional duties. Indeed, some of the strongest language in the GATT articles is contained in Article 6, as injurious dumping is in fact condemned. If you looked at the time period prior to the Uruguay round, you would have found that there were a handful of major users. These tended to be countries who had undertaken substantial tariff bindings, and typically Canada, Australia, the European Union, and the United States were viewed as the major four. New Zealand, South Africa, outside of the apartheid sanctions regime time period, and Mexico were other major users prior to the WTO coming into creation. But the big four accounted for over 80% of the cases if you looked at cases brought in the 1980s. And so a lot of times this was used or viewed as a relatively specialized area that seemed to benefit only a handful of countries, even though many countries had argued for it at the founding of the GATT back in the 40s. However, when you get through the Uruguay round, virtually all members have undertaken very substantial tariff bindings, and there have been some significant closures of other safety measures, if you will, that countries had used, greater restrictions on the ability to use balance of payment, exceptions being one, which meant that there was a great deal more interest amongst many countries in using those rules within the GATT and WTO that were sanctioned and authorized for member countries to use. Not surprisingly, as you look today, there have been 41 countries, 41 members, since the creation of the WTO who have brought at least one anti-dumping case. And the largest user was a non-user 10 years ago, and that's India. If you look at the countries who have brought at least 100 cases over that 10-year time period, you find that Argentina, South Africa, Brazil, and China, in addition to India, are all in those ranks. And there are many countries, other developing countries, who have brought 60, 70, 80 cases during that same time period. So it is a law that has much broader application today. And in fact, for most countries, if you take a look at the incidence or their use of trade remedies versus their trade flows, what you find is that it is usually a positive signal when there are more members who have got trade remedy laws on the books, because it usually means that they are liberalizing their system and that they are opening their markets to increased import competition. So this should be viewed as a positive, although most people tend to view the mere fact that there are more users as somehow an evil in the system. Sounds like a lot. There have been 2,700 cases around the world in the first 10 and a half years. Interestingly, versus the statistic I gave you earlier of more than 80% of the cases having been brought by 4 countries or 4 members, in the pre-WTO days, 60% of the cases in the first 10 and a half years under the dumping law have been brought by developing countries. The traditional major users are down to 37.5%. I would say this is a very strong and positive development for the overall trading system. While members may file cases against any trading partner, and if you look at who brings cases against whom, you will find, not surprisingly, that large global traders are involved in cases around the world. It is also interesting, and not, I guess, surprising, that many cases tend to be with your neighbors. And that's because you tend to have large trade flows with your neighbors, and if you look at the trade between the United States and Mexico, we account, I believe, for something like 70 to 80% of their imports. And so one would have to ask, if Mexico has a dumping law and they're not using it against the United States, exactly who would they be using it against? I took a look at Argentina as one example. Over 10 years, they had 193 cases that they brought. The largest number were against China, 40, but a large number were against their largest neighbor and trading partner, Brazil. While there is a lot of discussion about the relative importance of trade remedies, and certainly those who use them perceive them to be important, and those who find themselves having the law used against them perceive them to be significant as well, when you look at it from a global perspective or from a national perspective, usually there is a tiny amount of overall trade that is affected. Studies that have been done in the United States, in Europe, in Canada, and Australia have typically found that the volume of trade affected in any given year is almost always under 1%, usually well below 0.5%, and that tends to be true with virtually every country around the world who has them. So sometimes one has to ask, what is all of the hullabaloo about a trade remedy which has, at the end of the day, a relatively small effect? It's also not surprising that with the passage of time, with a lot of new users, with a lot of new provisions in the Uruguay round agreements, that at least some members wanted to include rules, including anti-dumping, as one of the topics to be included in the Doha Development Agenda. And while the United States objected to it at the beginning, in fact, they agreed to permit that to go forward, and that has occurred. The Objectives of the negotiations are what you would expect they should be, with a very major revision to the agreement being only 10 years old. That is, in light of experience and the increasing application of these instruments by members, we agree to negotiations aimed at clarifying and improving disciplines under the agreements while preserving the basic concepts, principles, and effectiveness. You would expect that what members would be looking at is, what are the things that are new, that we have some experience now, how are those working, what can be done to further improvement, what areas have there been disputes on, perhaps where clarification would be helpful. And at least for the United States, an important part of the inclusion of rules and anti-dumping in particular in this was the language to preserve the basic concepts, principles, and effectiveness of the agreements. As you know, to date, there have been many members who have presented a very large number of issues that they perceive merit consideration. While the process has been underway for a long time, it is hard to say what will come out of the negotiations. You have members who come at it from a variety of angles. There are members who perceive their interest as largely being export interest, either because they themselves don't use trade remedies, or because they are large net exporters and perceive this to be an area where they would like to significantly tighten the ability to use remedies. You have other members who come at it from the perspective more of those wanting to see that the rules are maintained, i.e. taking more of a domestic industry perspective, and you have a number of countries who are coming at these negotiations trying to take into consideration their interests on both sides, both from an importing and from an exporting situation. And importantly, you have many countries who are using rules as one of their bargaining chips if they have sensitivities or important objectives in one or more of the areas, some of which I understand you had discussed this morning, whether it be agriculture, NAMA, or services. As you probably know, through the middle of this year, the process is largely focused on discussing papers that have been presented or are being presented by various members to try to whittle down those issues that seem to have significant support amongst the members who are participating, those that seem to have some merit or are likely to garner sufficient support to be included in a draft. First draft, and when the real negotiations tend to take place, will be after the summer break, as the first draft is due out at the present time by the end of July. In addition to what's going on in the rules negotiation itself, there is a satellite area called implementation, which consists of a large number of issues that developing countries felt should be renegotiated as part of the launch of the Doha negotiations, and covered virtually every area of the Uruguay round in the WTO. And not surprisingly, it includes a number of issues in the rules area, whether dumping or subsidies, and I think there may even be one or two safeguard issues in it. So there are actually two fronts on which negotiations are occurring in anti-dumping. One is in the rules area, which is where most people are focused, but there are also a handful of issues that are out in the implementation process. U.S. negotiating objectives are consistent with the longstanding position of the Congress to maintain strong trade remedy laws here in the United States. Some of the U.S. objectives have been to clarify rights under the agreements where there's a view that the appellate body or panels have created obligations not agreed to. Others pertain to protecting our exporters by improving transparencies of other members. One of the reasons the U.S. tends to be the target of a lot of cases in the rules area is that most other countries have very poor transparency. We have very good transparency. Transparency comes with a cost. Those of you who participate in case knows that those costs tend to be legal fees. Transparency and due process tends to be expensive, but the U.S. is anxious to have improved transparency, improved due process for our exporters abroad. so that they have an opportunity to have the rules applied in an even-handed manner to them wherever they happen to be subject to cases. Let me give some personal observations, give my colleagues on the panel an opportunity to be concerned. Surprisingly, those who would like to have increased discipline in the system have not focused on an area where, in fact, there is probably a strong argument that can be made, and that is to see that the duties excess do not exceed the level of actual ongoing dumping. About the only system in the world that gives producers abroad a reasonable chance of that occurring is the United States. Most other systems, which are prospective systems, do not provide that opportunity. Most countries agree that you should take unnecessary cost out of the system. They don't really focus on what that means, but if you look at the United States and you take a look at standing as an issue, that was an issue desired by many countries, but if you look at the results pre and post, there have been no cases that have failed the standing test. It has added an enormous amount of cost to the process. It has not changed the outcome of ITC decisions, nor has it changed the outcome of cases getting filed. So it is an area where there's excessive costs in the system. The other items I have up there I will leave so that I finish on time. Thank you very much.
Thank you, Terry. Dan?
Thanks. Thanks, Aloysius. My name is Dan Eikenson. I'm from the Cato Institute here in Washington. We are a public policy research group, and I work with the Trade Center. We obviously focus on trade issues, including anti-dumping. We've written quite a lot about anti-dumping, and I would invite you to visit our site, freetrade.org, to see what we've written, because it's obviously more extensive than what I'm going to be able to cover here today. Aloysius asked me to talk about prospects for real reform and what's going on in the rules negotiations. Terry's slide should indicate to you that there is a new emerging constituency for the anti-dumping status quo. Certainly, use of anti-dumping has proliferated around the world, and that shouldn't be seen as a very positive sign in terms of how far we can go with AD reform. I was listening via webcast this morning to Tim Rife from the Congress, who presumably is reflecting the sentiments of Congress, which is really what's going to matter at the end of the day. And his perspective was that he doesn't quite understand Congress doesn't seem to understand what the big deal is. Why do countries want reform? We labored hard to get reform in the Uruguay round. What changes are necessary? And if in fact there is a lot of problem around the world with the anti-dumping rules, why hasn't there been more litigation? Or why hasn't there been litigation? Why haven't there been many disputes? Well, for starters, there have been quite a few disputes over various U.S. practices. And I focus my critique primarily on the U.S. because, as Terry said, it is pretty transparent, and I'm here, and the information is accessible. But certainly, there's anti-dumping abuse going on elsewhere. But in the U.S., we've had cases concerning zeroing, the arm's length test, calculation of all others rates, currency conversions, sunset reviews, not to mention the Byrd Amendment, which I just mentioned. That suggests that countries are anxious about various reforms, but litigation is costly and it's time-consuming, and very often countries opt not to implement the suggestions of the panels in the appellate body. Let me speak in terms of what I would have hoped to have seen in terms of anti-dumping reform, and then I'll put in perspective where we are. I mean, I don't think we need an anti-dumping law. All right, we already have a safeguard law, and I think the safeguard law could be made more user-friendly by maybe lowering the injury threshold. We don't need anti-dumping because, if we eliminated anti-dumping, we would eliminate the costs associated with calculating dumping margins. The whole procedure is performed by the Commerce Department. We would eliminate the stigma of unfair trade, unfair traders, and all the problems that creates. I don't think it's going to happen, but I think that we could have been on target to achieve bigger reform than we're actually going to. If we recall, when the Doha round was launched in November 2001, Robert Zoellick, then USTR, had received lots of letters and calls from Congress telling him not to put anti-dumping on the agenda. It's off limits. We can't negotiate it. Well, at the end of the day, Zoellick decided to include anti-dumping, and I think he recognized the U.S. was outnumbered 141 to 1 on the issue, and that the round would not go forward without the U.S. agreeing to it. Well, in an effort, I think, to limit the scope of the discussion on dumping, that famous language was inserted that says that we agree to negotiations aimed at clarifying and improving disciplines under the ADA while preserving the basic concepts, principles, and effectiveness of the agreement and its instruments and objectives. To me and to my colleagues at Cato, although this was an effort to limit the debate, it looked like a huge opening because what are the basic concepts and instruments? They've never really been agreed to. Dumping predates the GATT. Every successive round, we've just taken it for granted and assumed what the basic concepts are. The U.S. government, other proponents of the status quo, argue that we need an anti-dumping law because of foreign government policies, market-distorting policies that bestow unfair competitive advantages upon foreign producers. Maybe high tariffs, maybe failure to enforce bankruptcy laws or anti-competition laws, provides maybe a sanctuary market or enables companies to produce for a long time without reaping any profits. So the idea here with the sanctuary market is that, well, if you're able to charge higher prices behind a tariff at home and cross-subsidize cheap export sales, then there's something unfair and artificial about that. The problem with the anti-dumping law and the agreement is that there is no attempt to ascertain whether these market-distorting practices exist. The U.S. position relies on explaining the need for anti-dumping as being related to the fact that there are these market-distorting policies abroad. But when you file an anti-dumping petition, you don't identify what those market-distorting policies are. So it seems to me that one of the reforms would be to include that provision, require the identification of the market-distorting policies. Initiation of the case would therefore be based on whether or not there's credible evidence as to whether or not there are market-distorting policies. And from there, from that basic idea, then you can look at the actual details of anti-dumping, of the agreement and of the national laws. Is a cost test really warranted? Is it necessary to compare the average selling price in the export market to the average selling price in the home market of only above cost sales? Does that mean if you have sales below cost, is that not enough evidence that there is no sanctuary market? So there are a lot of inconsistencies between the law and the rationale for it. So we identified 21 reform proposals that are all following the notion that we need to preserve the basic concepts and principles of the anti-dumping agreement. At the early part of the round, there were some letters in the rules group that I thought were going to be pretty hard-hitting from Japan and from Hong Kong, questioning the United States really along this line. Why do we need anti-dumping? The U.S. never replied to those questions, and after a while, what we started to see in the rules the submissions we started to see were more along the list of sort of a laundry list of reforms. They're good ideas, but they're not anchored to any theory. And as a result, I think you have this laundry list, and it's easier for those who are opposed to reform to sit back and say, well, revising the cost test or changing the asymmetry of indirect expenses, those are just efforts by unfair traders to try to weaken the law. We had an opportunity here, I think, to really improve its aim, but we may have missed the boat on that. There have been over 100 submissions, maybe 120, on a variety of issues. They cover things like related to the initiation of the case, related to the calculation of dumping, related to the calculation of injury or the determination of injury, as well as various what I call safeguards, although that's not a really good term because it could be confused, or hedges, such as the lesser duty rule. That has been proposed by the Friends of Anti-Dumping Reform. I think that would be a good idea. The idea, you're probably familiar with it though, would be to impose the lesser of the duty necessary to remedy injury versus the the anti-dumping duty itself. Other safeguard hedge issues would be to raise the de minimis level to 5%. I don't see why that should be a big problem. There are so many assumptions that are undertaken in an anti-dumping analysis. There's so many imprecisions. Even though we do have a transparent system, and the Commerce Department will write up its explanation for all of its decisions, there are a lot of assumptions that the Commerce Department makes there. Change those assumptions very little, you can change the outcome dramatically. On the initiation side, there's talk about trying to raise the standards of initiation. After all, about more than one-third of cases result in no finding of dumping or injury, which means that a lot of companies are going through unnecessary costs. It's just being subject to an investigation is trade diverting. You lose clients and customers. It takes a long time. I think that it would be reasonable for us to raise the initiation standards somewhat. Is this going to be feasible? It's hard to say. I think that there is this emerging constituency for the status quo. We'll probably get some reform around the edges. Nothing dramatic. I'm seeing anti-dumping use has tailed off recently. Has a lot to do with the fact that the steel industry is pretty healthy. Has a lot to do with the fact, I think, that supply chains are becoming more internationalized now. And as a result, you don't see companies, I think, or industries will be more reluctant to bring cases. So I'm also concerned about countries like Brazil. I mean, Brazil is using the law. I'm wondering how countries are going to be able to sell NAMA reforms to their industries if an agreement is also going to include substantial anti-dumping reform. I think Terry referred to the fact that countries are using this because they are opening up more and they are engaged in trade more, and to a certain extent it is a trade-off. It's not a good trade-off, it's a political one, but it gives me reason to doubt that we're going to see dramatic reforms. I'll stop there.
Thank you, Dan. Penny?
Well, good afternoon. First, I'd like to thank the ABCI Institute for inviting me to be here today, and Alizio, the chair of the conference, and also of this panel. A panelist said today that it's very difficult to talk or to discuss a negotiation if you are not in it. So I'm not in the negotiation, so what I will try to do is to give a little bit of an idea of what could happen to the practice. And I'll try to focus not only on anti-dumping practice and rules negotiation, but what impact of rules negotiations on anti-dumping practice. This first part is, we don't need to stress anymore how important it is for the negotiations, the rules negotiations. Has been talked today for many panelists, and we are all here discussing that, especially because the barriers, tariff barriers, should be lowering, and then more and more countries, as Terence has showed, will be tempted to use even more anti-dumping rules. Of course, there are many USA sensitivities because of the Trade Promotion Act, Authority Act, and has given a very narrow mandate, and that mandate has been introduced in the Doha round mandate 2. So we know that there is a, let's say, a constructive ambiguity in terms of what countries can do in the rules negotiations, and that ambiguity will actually lie on the eyes of the beholder. How can you assess whether a given reform will or not improve the instruments of anti-dumping or the rules? So it really relies on who will be affected, whether the exporters or the importer. This leads to a problem to, not this, but the overall development of the round because of the emphasis on agriculture. And we have seen today the representative of Brazil before Geneva, the ambassador, has said very clear that if we don't move with agriculture, then we are not moving with anything. Then we have to see what will happen to agriculture. Of course, the developing on rules, but that will hold some trade-offs inside the rules negotiations before we get to the end, or at least to halfway to the end, which should be perhaps July when we have the first draft. Just a short overview. We have, I would say that we are in a fourth phase of the negotiations. First phase, 141 proposals that were submitted. There has been a compilation of the issues of the proposals. Then there was a second phase with informal sessions and proposals by the countries. The third phase, the chairman of the rules negotiations has stepped in and has engaged the parties into and plurilateral sessions. We know that Brazil has been very active in these sessions, and all other countries. Different groups have appeared as the Friends of Anti-Dumping, and more recent the Middle Ground Group. And now I would say that it's the fourth phase after Hong Kong, where they are beginning to prepare the draft test, which should be, as Terence mentioned, ready by, or at least a first draft by July. One interesting point, and I will refrain from trying to do a comprehensive review or comment comprehensively the negotiation because it's so vast. But I will pinpoint on some interesting issues that have come up. One of the issues is the relationship between rules negotiations and dispute settlement. We have seen some proposals made by members from one side trying to guarantee some results of dispute settlement, and other trying to undo some results. For example, on the zeroing, although there are 3, 4, 5 cases on zeroing with 20, 29 anti-dumping measures being challenged by the EC, by Japan, by Mexico, we have seen that the members 14 countries have proposed to have zeroing expressly prohibited. One other thing, for both original investigations and all subsequent reviews, we have a panel on the EC zeroing case that ruled that zeroing should not apply to administrative reviews. So we have to watch out whether it should also, whether the countries will request that zeroing is also explicitly prohibited for administrative reviews. With respect to privatization, that actually not anti-dumping, but it's countervailing. But it's a way of illustrating how the dynamics of the negotiation dispute settlement is developing. It's interesting that the U.S. has proposed some changes on countervailing measures agreement or part of the SCM agreement on the benefit pass-through rule, and also on the allocation periods for subsidy benefits, which were both part or the subject of a decision of the appellate body. Also, a very interesting point is the non-attribution rule, which is you cannot attribute to another factor that is causing injury to the domestic industry the effects of the dumped import. So you have to distinguish what is caused by dumping and what is caused by other factors, such as contraction in demand or change in the pattern of competition or other factors. What is interesting is that members have asked, well, how do I separate and distinguish those factors? That's very difficult. How do I do that? I have to hire an econometrist. I have to go that far. A reasonable explanation would be, or how do I do that? So the U.S. has submitted that criteria should be introduced in the agreement, saying how you do that, because you can do that, and for a year you do, and then there is a panel that goes and says that the way you were distinguishing, you were separating, distinguishing was not good enough, and then you have perhaps 100 other measures that are that can be challenged under the same rule. Facts available, also interesting. In the U.S. hot rolled steel, there was a decision saying that you cannot give or put an undue burden to investigated exporters, and then Australia is advocating that it should also be explicitly introduced in the negotiation, in the agreement. With respect to dispute settlement, one interesting point is that the TPA has said, or has a premise that the dispute settlement would be undermining the effectivity of the trade remedies, not only law but also practice of the U.S. What we have found out is that in many of the cases where the U.S. has had a bad result in dispute settlement, in 5 cases it has not appealed. If you do not appeal of decision, it's either because it's not so bad or because you have conformed with it. The U.S. has appealed, and these are all pre-TPA cases, has appealed in the U.S. hot rolled steel on a matter of best information available, also on the arm's length test and non-attribution, and has also appealed on U.S. Byrd Amendment, which is not directly related to AD practice, but it touches, of course, the AD practice, gives an incentive for petitioners to petition. So one of the conclusions we have, and it's an interesting point, is that actually the TPA, the premise is actually wrong, because the record of the cases, the pre-TPA cases, they do not support, and that the WTO dispute settlement has respected U.S. AD law and practice. We can see that from these 3 only cases where the U.S. has lost, the best information available is a matter of an inclusion of a word that is not in the agreement, which is entirely, and that's a word inserted in the U.S. legislation, and then the arm's length test, which is not, as the appellate body said, there was a lack of even-handedness because it's not balanced even for when it is when you see whether a party is not affiliated, and then the non-attribution rule, which is inserted in the Article 3.5. In post-TPA cases, U.S. has not appealed in the OCTG measures case because it was a factual analysis of likelihood of continuation, and also on sunset reveal. I'll leave that to you because I have other points to raise and I have only 1 minute left. One have been dealt in the negotiations is a vast area, and you can see all the issues that have been touched. I will refrain from going to each one of them. There are some very detailed proposals, and what will lead us to it's more rules on rules will rise cost of enforcement for the authorities, will raise cost for defense. New rules will surely bring on new litigation because you have more rules. Give them to lawyers, and lawyers will find a way. They are very creative, and they will litigate over and over again, or not again because they are new. So enforcers have to keep track of Geneva talks, and petitioners, if it continues in the way it is, with all the proposals that have been presented, been introduced, petitioner should be ready for fun, because there will be a lot of new rules to discuss and to see how it should be applied. And that will not necessarily decrease discretion, because one thing is what you intended to have in the agreement, the other is what is afterwards, how that will be interpreted. Brazil has been mentioned and has now a twofold interest, because it is also applying, is on the top 10 imposers and top 10 investigating exporters. So we have internal controversy in terms of to which side we should be, and we have now come towards the center, somehow leaving the friends of anti-dumping a little bit without our fully support. And finishing, I think that, and that's a provocation, Alois, if I can already begin the debate, that I would like to get back to the panel, is that perhaps causation should be the focus. Dumping, Dan Ikenson has some papers saying what are the devilish details of how can you always find a dumping finding, because either on facts available or because of price construction, you generally, or at least in the US, you always find dumping. That's something that has been submitted. Multiplication of rules will hardly reduce discretion, as we have seen. For injury, the problem is that generally authorities just lay out the facts, just lay out the numbers, and do not engage in a deep analytical examination of the matter. So what brings us to, and this is my last slide, is should causation be the point for us to focus on in the negotiations, so that to have real application on cases where it really matters, and taking a very realistic view that anti-dumping, I don't think it will be abolished, at least in this generation. For example, causation, how could that be tested? Through other factors I mentioned, how maybe setting tests and standards about how you separate and distinguish, and also how you reach a non-biased and objective assessment, which is requested under the special standard of review. There are some possibility of doing that in terms of standards. The panel in the steel safeguards case, and safeguards and countervailing measures cases and dumping cases, they have been part of the injury being interchangeably applied one to another. At least the appellate body has done that. And there they said that when you have a clear movement, coincidence on the movement of imports and injury, you have and then that's the name I give, would be a quick look analysis. You don't need to do anything else. Where you have not a clear coincidence on the movements, then you have to give a plausible and adequate explanation. Thirdly, when you do not examine the movements, or where there is a contradiction between movements of imports and movements of injury, then you have to give a compelling explanation. That type of rule can be interesting in terms of setting what is a non-biased and objective, so that you attain the rule under the special standard of review. And perhaps also improving on causation rules on price depression, how you calculate price suppression, and price undercutting may also be a more cost-effective manner of dividing which case should be applied, which case should not. Thank you very much.
Thank you, René. Well, I think you got enough material here to digest for the rest of the year, especially on rules. It's not the most popular subject, but certainly for us that work on it, very important. If I may use my authority here as the mediator, I'd like to just put some comments in before I open for questions. I think that there's a common denominator here between all panelists, and number one is the importance of the subject. I think that must have come through very clearly. The second thing I would like to make a point on is that it should be, in terms of negotiations, as important as market access. The way things stand today, what we have is the member countries of WTO left up to the authorities of each country the responsibility and the discretion to conduct the application of these laws. And what we're going to find is that the application of those laws, even though we're talking about the same laws, they're very different from country to country. And the results are absolutely different if they're conducted in one country and in another. And the reason for that is because discretion cannot be exactly the same. We're all humans, as was mentioned here earlier, and it doesn't happen the same way. So there's certain places in the agreement. I'm not going to go into that because we'll take a long time, but there are certain places in the agreement where discretion has been abused in many countries, and the solution for that will be to clarify the law and forget about this famous constructive ambiguity thing, because it may sound very nice, but for the producer or the importer or the exporter, it could be the difference between surviving and closing its own business. So it's very serious. So we shouldn't be playing with these things. And I've been using in my classes and with the people in the group in ABCI, I recommend it as a fantastic example of what I'm talking about. It's just because I'm here in the U.S., so I'm following what's happening here in the U.S., but I could be in Europe and find another case that probably happened. But the shrimp case for me it's probably the richest in information on how not only these investigations are conducted, but also in the impacts of this investigation. So again, I'm not singling out the United States here. I'm just saying because I'm here, I'm following this particular case. But if you take the shrimp case, and going back to my point that rules discussion should be as important as market access, I take the example of Brazil. The farm shrimping business in Brazil is very new. It's about 6 years old, no more than that. It came about as a market opportunity. So I usually make a parallel saying, imagine if the Doha round had concluded 6 years ago and we find this opportunity in the shrimp business and there's no changes in the rules. So we would be faced with what rules we have today. And what happened is Brazil suddenly became the most productive, competitive, cost-efficient producer of this particular crustacean. And we started exporting to the United States. We started very slow with about $3-4 million a year. And we ended up in 2002 with something around $80 to $100 million a year. A dumping case was brought in a year later. And just during the period of investigation, those exports to the U.S. were cut in about 60%. And last count last year, we were doing 100 million. Last year we did 11 million. And mind you, it's not the amount of the duty, because in the case of shrimp, in the case of Brazil, the all others rate, as you know, is the weighted average that applies to all the companies that have not been investigated, which is the big majority in Brazil, was around 7%. So it's not a big thing. But it's the uncertainty of the system that makes it that importers simply stop buying. And I think Terry referred to the prospective versus retroactive system, and it probably has to do with the character of the retroactive system. But the reality is, this is not one case alone. I like to use it because it has to do with the new industry, which is something that if we go into the Doha round with a big market access agreement and we find an opportunity for a new product, we'll start exporting that product, we'll become very competitive, we'll become very good at that product, and then suddenly you're hit with a case and you're out of the market. So the question is, what did your efforts with regard to market access gave you in terms of market access? You probably got it for a couple of years, but then it was gone. And then you say, well, my chance to do something in rules is gone because then I had something to bargain with. Now I don't. So I just wanted to make that point and just to call your attention as to how important the discussion on rules should be. And at this point, I would like to, before I open to questions, are there any comments that someone would like to make? Any questions?
Yes, hi. What are you expecting in the text that's going to be put forth in July, given the state of the negotiations now and the sort of range of positions that have been put on the table?
Could you identify yourself, please?
Yes, I'm Kim Frankena from GAO.
Okay. This is for the panel, I presume?
Yes.
For anyone, okay.
I have no idea. You know, it really depends. The conventional wisdom that I've been hearing is that if the U.S. negotiators have a lot of bacon to bring home to U.S. exporters with respect to the NAMA and agricultural market access and things like that, then the U.S. would be more willing to go along with more substantial anti-dumping reform. I don't know that that's necessarily the case anymore because we still need the push from those who are interested in reform. Then there are countries that are interested in reform, but many of those countries are developing their own constituencies who like the anti-dumping law. I think some of the bigger countries that would be pushing, some of the friends countries, are also now bilateral trade negotiating partners with us: Korea, Thailand, Malaysia. And I wonder to what extent, you know, the WTO anti-dumping discussions comes up in the bilateral discussions, and whether that will temper any push for more reform. So, you know, whether we're going to achieve modalities in NAMA and Ag, and whether we're going to be able to plug in those numbers by the end of December is still anybody's guess. And then I think the rules are here to sort of grease the skids for the 5 months remaining in the year. But I really don't have any idea what is ultimately going to be included.
If I can make some comments, it's interesting that even though it's a subject that is very controversial and some countries don't want to talk about it, believe it or not, is one of the most active